Hello, folks. Welcome to this very exciting webinar this morning, a very exciting collaboration between YACVic, Youth Affairs Council Victoria, and Youthlaw. And we have a jam-packed morning with presenters from Youthlaw talking us through all sorts of very important information related to our work with young people. My name is Sam. I go by he and him pronouns, and I'm Participation and Development Manager at YACVic. I'm going to do a little bit of emceeing and hosting up top, and then I'm going to hand over to the fabulous Youthlaw team. I'm working on Bunurong country today, and I'd like to begin by acknowledging the traditional custodians of the lands across everywhere that we're sitting and zooming in from today. I'd like to pay respects to elders, past and present, and acknowledge that sovereignty was never ceded and never has been ceded by any First Nations custodians. And this land was, and always will be Aboriginal land, best cared for by First Nations custodians with that deep ongoing connection to country for over 60,000 years, an incredible legacy, and one to sit in awe of for those of us who may not be First Nations ourselves. You are likely sitting on different lands. You are very welcome to use the chat to acknowledge country where you are today. We have got a few tools in the background where we're recording this, which you will have heard already. We have the transcript running, and you are welcome to have captions on your screen as well. My hot tip is to have the transcript up for you if you are trying to keep up with things that the speakers are talking about today. It's a really great way to just catch things that might have been said a few seconds ago that you might have missed. You are very welcome to change the name on your screen and include your organization and pronouns. This really helps with networking during the event today, but also afterwards. If you've heard someone speak and you want to try and catch up with them, you can find their details online or via YACVic as well. Now, we have three fantastic speakers from Youthlaw. We have Beth King, we have Lisa Nguyen, and we have Tina Pugliese. And they are here to talk about some very important pieces of youth work and sharing resources and sharing information about the updating of one of their key resources for the youth sector as well. So today we'll be talking about duty of care, privacy and confidentiality, and reporting abuse. These are key facets of the work that we do with young people day in and day out as youth workers or people working with young people within the youth sector. And Youthlaw are also working on the upgrade of their What Do I Do When resource, which is a companion piece in some ways to the Code of Ethical Practice for the Victorian youth sector, looking at the legal aspects of work that we do with young people. It's an incredibly important resource that hasn't been updated for quite a few years, and they've been working through it over the last couple of years, and are very excited to be sharing some of those new ideas, but also testing some of those ideas and hearing about where you're at in the sector and what might be useful for you in the ways that they update this resource. So I will, in a moment, hand over to the Youthlaw team. I'll be around in the background. Please do message if you have any questions. And we'll be using the chat for reflections and activities throughout the workshop. We will be also using breakout rooms today. It is an engaging and interactive webinar, not just being spoken to today. So I would recommend to try and avoid multitasking, focus in on the content, and get involved with the incredible discussions as well. So without any further ado, Beck, maybe you could spotlight Beth, Lisa, and Tina, and then take me off spotlight, and I'll hand over to the Youthlaw team at this point. Thanks so much.
Thank you, Sam. I too would like to acknowledge the traditional custodians of the lands that we're on today. For Beth and I, we're on Wurundjeri country today, and that's also where I live as well. In addition to acknowledging elders past and present and anybody who may be Aboriginal today, who is on the call, who identifies as Aboriginal, I'd also like to just remind people, I'm sure we all know this, that that Aboriginal people, First Nations people, are overrepresented in the justice space, and sort of mention the fact that we have new laws that have come through, the bail laws that really target people who are young, and in doing that we are also targeting First Nations people. So it's really incumbent on us to be allies for our young people who identify as Aboriginal or Torres Strait Islander. So just wanted to add that to that. Beth, would you like to start speaking about what we're doing today in our intros?
Thanks very much, Tina. And thanks so much, Sam, for that kind introduction. I'm joining in from Wurundjeri country. And of course, if you put in your country in the chat, it's been really lovely to see the range of countries that people might be joining from in the past. So feel free to do that. I'm Beth King. My pronouns are she, her. I'm an education and training lawyer with Youthlaw, and I have a background working primarily in the community legal sector, so in partnership with workers like yourselves, and really appreciating the expertise that flows both ways between our respective professions, and see this session today as an extension of that great practice that's integrative and collaborative. I'm going to just note that we do have a big agenda today, but this is designed to be an engaging workshop. So as Sam said, we're looking forward to hearing your ideas. It is part of the process of our update of our What Do I Do When resource, and we will be incorporating the ideas raised today into the update. And so you've got a direct line. We're going to be using an interactive whiteboard in addition to the chat, and you are welcome to add any ideas to that whiteboard today, and I'll keep it open for a week after the session to give people who maybe weren't here today but still wanted to share some ideas or things that you might think of after the session's ended. Later this year, after we've incorporated feedback and done some further reflection, we'll be in a position to share a draft resource with the sector, and we'll be looking forward to your further feedback on that. And obviously when our updated resource is live, then we'll be able to share that with YACVic, and that will be available on our website. Please do put any questions in the chat as we go, and there is actually a specific page on the whiteboard to note your questions if you're just in the whiteboard, and that's an easier way for you to put them in. And we might not have time to get to them today, but we'll make sure that we answer them and send around the answers after the session. Tina and I have looked at the amazing questions that were asked during the registration process and have written some answers to them already. We might not get to all of them today. Quite a few of them we will cover today, but for those we don't get to, you will get a written response in an info pack. And yeah, just a big thanks to YACVic for providing tech support. So the aims for today are that we're going to better understand Youthlaw's work and how we can help you to more confidently apply the knowledge of your duty of care, privacy and confidentiality, and child abuse reporting legal obligations to realistic fact scenarios. And as I said, it's to inform that update of our legal resource for workers. What do I do when? I'll just hand over to Tina and Lisa to introduce themselves.
Thank you for that, Beth. So my name is Tina Pugliese. I'm a social worker at Youthlaw. And in terms of the way we work in Youthlaw, we are an integrated process. So we actually have social workers and lawyers working together so that we're not just assisting young people with their legal rights. We are also looking at the underlying conditions as to why they could end up within needing legal representation in the first place. So very much we all work on a model of advocacy and very much work together to support young people in what they choose to need. You've spoken about the intros and the aims for today. In terms of what we are doing, I guess we'll first be speaking about Youthlaw's work and what we do. So there are many different areas of Youthlaw that we work in. So that's, I think that's, yeah, apologies. Actually, would you like, yeah, so we provide community and legal education, so much like we're doing today. Law reform and policy. So we do a lot of advocacy in that work. And additionally, the lawyers provide legal advice and casework. And at that point, young people are asked whether they would like to work with a social worker, or we do an assessment together of the young person to see if we can assist in their needs. And of course, all of that is voluntary. That's if they want to have a social worker involved as well. So I think, is there anything else that Beth that's needed there?
That was great, Tina. Thanks so much. And Lisa, I'll just let you introduce yourself as well.
Oh, sorry, Liz.
That's okay. Hi, everyone. Thanks for having us. My name's Lisa. I'll keep it short and brief, just mindful of time and wanting to really delve into the topics. I'm also a lawyer here at Youthlaw. I work really closely with Beth in the community legal education space, but I also work in the outreach program, so heading out to different spaces around Victoria to see young people where they're at. And yeah, if you want to know more about what we do here, please don't hesitate to reach out and we can answer questions along the way or after today's session. But yeah, thanks for being here and hope you get some stuff out of it.
Thanks so much, Lisa. Great. So moving on. So these are just a rough overview of the programs that Youthlaw provides. I won't go into all of them now, but suffice to say, we do a lot with young people across Victoria, and we're here for you. So if you have any questions in relation to your own practice, or you want to direct a young person to contact us, that daily helpline phone number at the top is your go-to, and we can take it from there. As we've said, we also provide a lot of support and information to workers, and we do have a number of resources on our website that support workers with their practice. So what do I do when? These are some of the scenarios that have been presented to us over the years, where workers are looking for legal guidance on how to respond to complex situations where they'll be managing a number of different obligations, both under their own code of ethical practice, their organisational policies, and a number of different legal obligations. We commit to sort of walking alongside you in these kind of complicated decision-making processes and provide you with clear information about the law in relation to these matters, which is to complement your other considerations that you'll have in your work. So just to start us off, I just wanted to give us 5 minutes for everyone to have a look at these scenarios and to think about whether one of these particular scenarios resonates with you, or if there's another situation that you would like some information about from a legal perspective, and then we can incorporate those into our update of what do I do when. So I'll give everybody 5 minutes now, and if you could just you can either put it onto the whiteboard, so I'll just put that link in the chat, or you can put it onto the chat directly. You should see that link in the chat now with the whiteboard. But if you don't want to go to the whiteboard for this activity, you're welcome to just put your responses straight into the chat. Amazing. I can see some really great work happening on the whiteboard here. So a young person is carrying a knife. A young person wants to take contraception without their parents knowing. Oh, there's a flurry of activity. It's fantastic to see. Young people talking about crimes. A young person's parents contact you worried and requesting information. A young person tells you about a past crime they've committed. A young person asks for a lift with you. Young person disclosing family violence. Young person's parents contact you worried and requesting information. parents requesting information about their child without consent from the young person and where there's no safety issues. A young person mentions doing drugs or illegal substances. A young person is not collected by a parent at a program. A young person discloses they are suicidal. A young person is being exploited at work. A young person's scared to go home. A young person has a negative experience with the police. Young person wants to take contraceptive medication, doesn't want their parent to know. Friends have mentioned that one of their friends is suicidal and has recently made an attempt. I'll just, at this minute, just take a moment to note that it's probably a little bit late, but that we will be discussing suicide and self-harm today, and to encourage everybody to take care of themselves. And please take the time you need. Just jump off if you need to take a break. We will take a 5-minute break in the middle, and the agenda's been popped in the chat. But yeah, we would really encourage everybody to speak to somebody if you are feeling that you need that, either during or after this session, and to really take care with yourselves as we deal with some difficult topics. Okay, taking young people, a group of young people on an excursion. A young person scared to go home. A young person, another young person scared to go home. You see evidence of self-harm. Young person wants to take contraceptive medication. You can see there's a few themes that are emerging here, which is really great and really helpful for us to see. Young person needs support in court. Yep, absolutely. Other workers sharing sensitive information about a young person where consent is uncertain or not provided. So we can see there some of those more difficult and complex situations. A young person's under the influence of drugs and alcohol at a program and doesn't want you to tell their parents. A young person asks for a hug when upset and then gets hurt when you explain that you cannot because they felt that they needed the comfort at that moment. A fight breaks out at our service. Young person sharing they're scared to go home. Young people can't get parental consent to go on a group excursion. Young person carrying a weapon or drugs on their person. These are so fantastic, everyone. And I can see there's still cursors dotting around. So I'm really excited to see that everyone's got such great ideas, and I can clearly see the depth of your practice experience in these areas. So I'll move on from that now, but I'm really mindful of the really fantastic insights that are being shared. So please don't let me stop you from continuing to add information here. Yeah, fantastic. So we'll just move on. But as I said, yeah, please continue to add. That's the great beauty of the whiteboard. You can just continue to add things as they occur to you. So this is a screenshot of the table of contents of the previous What Do I Do When, which was last updated in 2017. And just to give you, I don't expect you to read all of this content, just an idea of the breadth of topics that are currently covered in the resource. And by no means is this a limit to what can be covered. And you'll get these slide packs at the end. So you're welcome to have a review of those topics. So as I mentioned, there's kind of a constellation of considerations for workers when they're working with young people, which range from your professional code of ethics to other practice considerations that are based on your organisational policies, your input from supervisors, and then a range of legal considerations. We don't have time to cover all of the potential legal considerations today. I've included the ones that kind of seemed most relevant and obvious to me on this slide, but there's definitely many more, I'm sure. But yeah, the main ones are here. And we're going to focus today on the duty of care that we owe to young people we work with, privacy and confidentiality duties, and then situations where we may need to breach privacy and confidentiality in order to report child abuse either to DFFH or report a crime that is a sexual offence by an adult against a child to the police, where we may have a duty of care in those situations. To make that report, we'll be making those judgments around how to balance those different obligations there. So we'll start off now with duty of care. Just acknowledging that it's likely that you've had training on your duty of care obligations with your organisation. And so this is really focusing on the law behind duty of care obligations that you owe, give you that grounding. So duty of care is a legal obligation, and it's owed to certain people to protect them from foreseeable risk by taking reasonable steps. I'm going to go into each of those bolded concepts. You breach your duty of care if you fail to take reasonable steps, and this failure causes harm, which might be, for example, a significant injury, and then you and your employer or your employer can be sued for negligence. So when we say certain people, that usually applies to young people at your service, but it may apply more broadly. So it could apply to colleagues when they're at work. It could apply to the wider community. They're affected by your work. The legal phrase that applies is persons who are so closely and directly affected by your actions that you ought reasonably to have them in mind as being affected when directing your mind to the act or omissions in question. So whether you should act or whether you should not do something, you'll need to have these people in mind. What's foreseeable risk? It's a very difficult question. It's a risk that an ordinary, sensible person in your occupation would have foreseen had they thought about what might happen. An example might be taking a group of young people rock climbing, which involves a risk of foreseeable injury. Intravenous drug users have a duty to clean up needles so that clients aren't exposed. Or for intravenous drug users, apologies, we have a duty to clean up needles so that clients are not exposed. What reasonable steps are will depend on the experience, training and qualification of the worker, the relationship between the young person and the worker, the age and capacity of the client, and budgets and resources of the organisation. So in terms of experience, training and qualification, the standard of care expected of a team leader is higher than that expected of a new graduate. In terms of the relationship between the young person and the worker, it will depend on how well the young person knows, the worker knows the young person, apologies, and their characteristics, their personality, their history, the age and capacity of the client. So that will be, for example, if the young person has an intellectual disability or a health condition, the standard of care can be much higher. And in terms of the agency's policies and procedures, were there policies in place regarding minimum staffing levels, first aid training, etc.? And then in terms of budget and resources, was it difficult or impractical maybe for you to reduce the risk given the restrictions on the resources available to you in your role? Obviously, if you're in doubt, referring to your managers, supervisors or other reputable services is a really important first step. The key takeaways for duty of care are to ask yourself, firstly, do I owe a duty of care to this person? Secondly, are they at risk of foreseeable harm? And thirdly, what reasonable steps should I take to alleviate the risk of harm? So now we're going to go into some breakout rooms to discuss a case study, and you'll get these facts in the whiteboard on page 2. And I'll encourage you, to have a discussion amongst yourselves in the breakout rooms. There'll be approximately 5 of you in each breakout room, and to discuss what you would do in this situation, those 3 questions in relation to the duty of care. So in relation to whether a duty of care might be owed to this person, are they at risk of foreseeable harm, and what reasonable steps should be taken? And then if you can take some notes on the whiteboard, page 2, and then we'll come back together for a very brief reflection and then we'll move on. Welcome back, everybody, and thanks so much for your engagement with that question in the whiteboard. I could see the answers coming through, and just in case anyone was not sure how to navigate to the different pages in the whiteboard, there's a little icon in the top left-hand corner with 2 squares and a little 1. You just click on that and it brings up a side panel with the different pages there, and you can click on page 2, which is where people are adding their reflections about this case study, but you're welcome to add them in the chat as well. So it's been really fantastic to see that engagement with this topic. I'm just going to go to the whiteboard quickly to have a quick look at some of the thoughts that have been put there. Apologies for me jumping out. So it's looking really great in there. I can see duty of care lies with police when they arrive. Make sure Jackie isn't in the same space as the young person with a knife. Our duty of care to call police. Hopefully she would have had a plan prior to the incident based on previous self-harm and drug use. We would have had to enact that plan and revise it after, letting Jackie know you'll be contacting her emergency contact. I would say, yes, there is a duty of care for anyone accessing the services. Yes, there is a duty of care as the worker is across Jackie's experience with violence and as it happened within the service. Yes, there is a risk of foreseeable harm due to Jackie's history with violence, suicide and AOD factors. Reasonable steps would be a safety plan for Jackie. Another answer, the nature of the service would determine the level of risk and foreseeable harm. A duty of care exists. There is a risk of foreseeable harm due to Jackie's history. Yeah, so there's a consistency here that there is a duty of care and there is a foreseeable risk, and then it's about what reasonable steps. And we can see some safety planning, making sure that any safety plan that was in place is revised for future if there is. So obviously notifying police, I would say notifying health workers in relation to this matter. So there's some really good suggestions here. Yeah, I'm really impressed.
Yeah, it seems like everybody has thought about that need to think about what happens to Jackie, but also the duty of care to others around the area, and even the continual duty of care afterwards to learn from that, to contact people that are important to her, such as her, to continue that support. So that's really great. I think that sort of comes into group spaces in a very good way there, which is the next slide, I believe. But yeah, it's some really great thoughts there. Thank you.
Apologies for my screen coming on and off, so I'll just put that up. Should be.
Yeah, it's coming onto group spaces. So yeah, in environments like youth hubs, services, and other services, there are foreseeable risks to the client, but there's also foreseeable risks to others around there too, and there's foreseeable risks of conflict within there. An organisation has a duty of care to provide the following to minimise risk of foreseeable harm. So your organisation should be providing supervision, staff training, and also compliance with OH&S policies within the organisation. If there should be appropriate physical environments for that area, so for instance, in a public area such as a waiting area, there should be there should be staff present, for instance, if needed. So, and don't forget that your organisation has its own policies and procedures, and the stuff that we're saying here today isn't really overriding those policies and procedures in place. Again, you also have code of ethics as well, depending on where you work. I know many social workers use the social work ASW social work code of ethics as well. I think that's the part for this slide.
Yeah, thanks so much, Tina. I think it's really valuable to have So obviously Tina's one of our senior social workers, and as youth law is a completely integrated practice now, we have lawyers and social workers working alongside in all of the work that we do. And so it's really valuable to have that sort of co-expertise in the delivery of our education as well. So yes, in terms of best practice, the best thing is to talk it out with a supervisor or internal legal team. You're also welcome to call Youth Law for some information. And now what we might move on to is our privacy and confidentiality topic. So I'm just going to launch into that. I'm mindful of time. So just returning to our summary slide here, you can see that there's a number of considerations and that we're moving on now to privacy and confidentiality. So the duty of confidentiality is an accepted ethical principle in youth work, but it's actually also a common law legal requirement. In addition to the duty of confidentiality, there are various privacy laws which give individuals control, choice, and access to and understanding of how their personal information is handled. And you can see that the three pieces of law that relate to privacy laws in Australia are on the slide: Privacy and Data Protection Act of Victoria, and then there's also the Health Records Act of Victoria, and then there's the Commonwealth Privacy Act, which includes the Australian privacy principles. So the slides here are just giving a summary of some of the considerations raised in those pieces of law and in the common law duty of confidentiality, which is also an ethical duty. Common law is the law that's been passed down through decisions of judges and in the courts interpreting the legislation. And in Australia, we use both the common law, the decisions of judges and their reasoning, and the pieces of legislation to inform our understanding of what the law is. So what information is private? This is a broad summary of the kinds of things that will be private. They're divided into three categories: personal information, sensitive information, which is a subset of personal information, and health or genetic information, which is itself a subset of sensitive information. So they sit inside each other like the little dolls that sit inside each other, and there are different levels of protection that apply depending on the type of information. So I'm going to just highlight some key practice tips in relation to personal information, which may also be sensitive, which may also be health information. We should only collect information if it's reasonably necessary for your organisation's functions or activities. It should be collected by fair and lawful means. We should explain our purpose for collecting it. We should collect it directly from the person if possible. And if it is sensitive information, it should only be collected with consent. And that consent needs to be informed. The person needs to have been given enough information to understand what they're consenting to. It needs to be voluntary, so the person needs to feel like they're not under any pressure or coercion to make that decision. It needs to be current, so they need to have given consent recently. It needs to be specific, so it needs to relate directly to the thing that you're asking them. It can't be sort of a blanket consent. You need to also ensure that access to the information within your organisation is limited to those who require it. And then in terms of the use and disclosure of information, we shouldn't use or disclose personal information for any reason other than the primary purpose that it was collected, unless an exception applies. And that exception might include consent. So the young person might have given us that consent to use it for another reason and disclose it for another reason, or if maybe that person would have reasonably expected it to have been used or disclosed. If the secondary purpose is related to the primary purpose, or in the case of sensitive information, the secondary purpose needs to be directly related to the primary purpose. And then that potentially there's a serious or imminent risk to life, health or safety, or permitted or required by law. So the last two are those more urgent situations where there will be a need to breach privacy or confidentiality, either to protect the young person or protect a member of the community, or because you're responding to a legal requirement, which might be because abuse needs to be reported. You may have received a subpoena in relation to a legal court case, or there may be a notifiable disease involved where you need to report to the Department of Health.
I guess one of the things that we should think about when we're talking about young people and consent, we should actually think about the fact that that can change over time. So, for instance, if a young person gives consent for you to speak to their partner, that partner may change over time, or their relationship with parents may change over time. So it is really important to continually have that conversation and possibly remind a young person, if you think they're going to be disclosing something that you may need to report, just remind them of that obligation so that they're making continual informed consent about whether you're going to share their information and whether they want that information to be shared. So we're going to be exploring some common challenges when protecting a young person's privacy in the next slide, in the next part of this. We have had this as a question both previously before this session and today. When a person threatens self-harm, we're not going to be covering it right throughout this as a what to do when, because everybody has different clients and different obligations from their particular organisation that they're staying at, but or they're working at. But it does have a lot of contextual things to think about. So, if a young person, for instance, if a young person if you know them well and know that that is the way that they communicate that they're distressed and know that they're not going to act on it in that they haven't before, but this is something that they say on a very regular basis, having a conversation with them would be perhaps more important or more appropriate than to immediately report it. That can also be the type of self-harm and whether it's something that is dangerous, whether there's a thought of ending their lives can be part of that too. But there's also, I guess, different places and different policies that have that occur within spaces. So threats to self and others in some spaces, like in schools, could mean that you immediately do need to report it. So you need to let that person know that you have to report it, for instance, to their parents, guardians, etc. But in other workplaces, so for instance, if you're working with young people that are over 18 and not at school, for instance, that may look quite different. So superficial self-harm, such as evidence of superficially cutting that looks like it's healing, may have a very different response to somebody who is actively planning on harming themselves in a way that is in risk of severely hurting themselves or worse. So yeah, I guess it's you can justify overriding confidentiality when it is something that does need to be actioned immediately, but you do also need to think about the ongoing relationship with that young person and whether there could be further risk if you report that, and it is something that they present with as a fear or something that they speak about on a regular basis, and you know that it's, for instance, picking skin is very different to cutting themselves in a deep way. So yeah, again, I might remind you to, if this is content that you don't want to hear right now or it's not the right time, you're welcome to come back in a short while and take care of yourself.
Thanks so much, Tina. I really appreciate that perspective from a social work lens. And I guess the reason that we led with a social work perspective in relation to this issue is that in some respects, the legal answer can feel quite simple. So if a client is threatening self-harm and you think that there's a risk, imminent risk to themselves, or I guess to others, but it would be more to themselves in this instance, then you've got a duty to breach confidentiality and privacy in that situation to get them help that they need. but the grey in this question is in relation to the assessment of the imminence of the harm, and that's where that social work lens is so valuable. Just move on to the next slide. So we're just going to jump back into our case breakout rooms now to have a chat about Jill and Ruby. So you'll find them on page 3 of your Zoom whiteboard. Just chuck in the chat your thoughts if you're having trouble accessing the whiteboard, or feel free to message Sam or Beck if you need some help getting in. We're going to take maybe slightly less than 10 minutes to discuss this case study in your breakout rooms, and then we'll come back and have a brief reflection together.
I think that's everyone back. Yeah.
Fantastic. Welcome back, everybody. I hope that you were happy to have a bit of a chat about that case study, and having a look at the whiteboard. It does look like there's some really fantastic suggestions and ideas here. So I'll just quickly highlight a few of them. So a really interesting one that's been liked: keep in mind that the person calling might not be who they say they are. Interesting perspective. Depending on if Ruby has seen Mary at an appointment, would not give out information that Jill is a client. That's interesting, yeah, because she's got that confidentiality duty to a client. Yeah, depending on the consent given, do not confirm or deny that the young person is accessing your service. Yep, that's a good point. A great suggestion here: 16 is considered a mature minor who should have the right to informed decision making, and we're going to speak about that. So that's a really, really key point there. Yeah, and then to really keep Jill in the loop here, so to inform her about her mother's calling and the conversation that's just been had with her mother, and to reassure Jill about your duty of confidentiality to her. Yep, another one of having a chat with Jill about her mum calling.
I think it's also really important to ask Jill if she wants her mother to know as well, and whether she needs support, if she does want her mother to know, whether she needs support to have that conversation with her mother. So offering to be the conduit there as well if that's needed, because again, young people can change minds. In fact, we all change our minds. So yeah, thinking about that.
Absolutely. Another really good point: over the age of consent, and there's no immediate risk that can be mitigated by telling mum. So some key concepts there again about whether the young person, so Jill in this case, is old enough to give informed consent, and to say that she doesn't want her information shared with her mum, whether she's a mature minor. A couple of people picking up on that theme. Some great steps here. So 1, put the person on hold. So put the mum on hold, don't give them any information. 2, check the documentation for Jill's consent and the relationship context. And number 3, if no consent, do not share information about if the client is engaged with the service. Really good step-by-step suggestion there. Yeah, just a reminder that we don't know the context of Jill's relationship with her mother and whether Jill would want her mother to be involved. So just Tina's really key point there about asking what Jill would like.
Yeah. Yeah, even if you do have consent to speak with her mother, she may not consent to you speaking about this particular situation. So she may be fine with speaking to her about almost everything else. So it's really important to check with Jill to see whether that's something that she would want, even if you do have the consent to speak with mum.
Really great point. I can see here too, there's also I guess an alternate scenario where perhaps if like a sexual partner of hers is over 18 and Jill is 16, and there's perhaps some questions about consent because of a power imbalance and the other person's in a position of care or responsibility, perhaps is what that question is pointing to. So that is not what we'd envisage in that case study, but a really good alternative, that context to consider. And we will talk about mandatory reporting a bit later on. And then a really good key point that also from a social work perspective, we can help the young person get their own Medicare card to avoid a scenario like this. So that's really helpful. Yeah, and doesn't meet the threshold for a risk or harm for breaking confidentiality or privacy. Yep. Yeah, really great. So I can see people kind of applying the test about whether to use or disclose without consent in the case of an imminent risk of harm or if there's a legal requirement. So I can see people giving consideration to those two things when they're looking at this case study, which is really helpful. Great. So yes, I would say that Jill probably has no obligation to breach. Sorry, Ruby has no obligation to breach Jill's confidentiality just because her mother demands to know information. Tina, I'll hand to you just to give some more information from a social work lens, and then I'll talk a bit more about that mature minor concept.
Thank you for that, Beth. Yeah, some really great thoughts throughout this. Generally, from a social worker perspective, we want to make sure that that Jill's choices are taken into consideration and are actioned here. That can be different depending on where you work, on what you must share with a parent. So, for instance, in some educational facilities, that could be quite different to a healthcare facility. So, and what I'd like to mention also is this doesn't change if somebody has a disability as well. So, for instance, a 16-year-old with an intellectual disability, we have to assume that they have an understanding unless we find otherwise. So they still have the right to the same sort of protection in terms of their confidentiality as a young person without a disability. Yeah, the big thoughts here are making sure that even if you have got written consent, that you consider that person and actually ask her, do you consent for your mum to know this about you? And writing that down is really important too. And what I tend to do when it's something that's ongoing, I again check whether that person wants a parent to know. And if there's somebody that they would like to support them with this. So just because they don't want necessarily their mum to know, it doesn't mean that they may want another adult in their life to know and to help them with decision making in relation to that. I think that's probably the social work perspective for this.
Thanks so much, Tina. And I'll just briefly speak to this concept of being a mature minor. So it comes from a court case with a woman, Miss Gillick, who had some daughters who wanted to seek contraception, and she took the Department of Health and Social Services to court because it had issued some guidelines around family planning that said that in some cases a health professional could be justified in prescribing contraceptives to an under 16-year-old without parental consent. And Mrs. Gillick lost in that case. So the decision was that a child under the age of 16, and there's no minimum age limit, as we'll talk about, they have the legal capacity to consent if they've got sufficient maturity and intelligence to understand the nature and implications of the proposed treatment. So that phrase, sufficient maturity and intelligence, you can see is reflected through these specific factors that we might apply to determine their competence. And they're just the ones on the slide. So their age, their intelligence, their social maturity and awareness. Maybe they're quite independent already and taking care of things at home. Whether the seriousness of the matter, so this is in relation to a health context, so the seriousness of a child's condition, the risks of what's being proposed, so the treatment, and their person's understanding of what's being proposed. And then in the moment, when you're assessing capacity for anyone, not just young people, We will be thinking about in that moment whether they've got the ability to understand information, remember it, so hold it in their mind so that they can weigh up options and then communicate their decision back to you. So two adjacent concepts that you'll need to have in mind when you're thinking about whether a young person can give that informed consent. I'm just going to head now to a break. We'll have about a 5-minute break, and then we'll come back and we'll chat about our next topic, reporting abuse. Hi everyone, and welcome back to our training. So we're going to move on to our final legal topic for today, reporting abuse. And I'll just start by having a brief discussion about what we have to weigh up when we're thinking about reporting. So that's our, yep, fantastic. Thank you, Lisa. So when we're weighing up these kind of considerations, we could envisage it as having a duty of privacy and confidentiality on the one hand, a duty of care kind of in the middle, because we may have a duty of care to retain somebody's privacy and confidentiality, but we also may have that duty to avoid that risk of foreseeable harm by breaking privacy and confidentiality and telling somebody else. So it can kind of go either way. And then on the other side, we've got our duties to report matters to child protection and to the police. And I guess overseeing this as well is your professional code of ethics. And so in your practice each day, you'll be asked to weigh up these various legal obligations and make a decision about what you should do. And so I'm going to firstly speak about mandatory reporting. So under the Children, Youth and Families Act, anyone may report to the Department of Fairness, Families and Housing, or DFFH, otherwise known as child protection, if they reasonably believe that a child, that is somebody under 18 years old, is in need of protection. So anyone may, but mandatory reporting is where certain professionals must report to DFFH or child protection. And the test for that mandatory reporting requirement is if during their employment they reasonably believe that a child, someone under 18, is in need of protection because their parents are unable, or parents or carers are unable or unlikely to protect them from significant harm as a result of physical injury or sexual abuse. They can choose, a mandatory reporter can choose to report in relation to other types of significant harm. So significant harm could be a result of physical injury or sexual abuse. It could also be the result of emotional or intellectual harm, physical harm to physical development or harm to health, or abandonment or parental incapacity. But mandatory reporting relates only to significant harm that results from physical injury or sexual abuse. The report must be made as soon as possible, and it has to be made after each time that that professional has formed that belief on reasonable grounds that a young person's in need of protection. Failing to make a report in this circumstance, if you are a mandatory reporter, is a criminal offence. So it's different from duty of care obligations, because duty of care is what we call a civil responsibility. You can be sued by another person for breaching your duty of care to them and causing them harm. But breaching these mandatory reporting laws as a mandatory reporter is a criminal offence, and you can be charged by the police for that offence. So it's a different type of legal wrong. It is a defence if you can prove that you honestly believed on reasonable grounds. So there's two parts of that. It was honest and it was reasonable to believe that someone else had already reported the matter to DFFH and they'd reported everything you were aware of. So you had nothing else to add. And if we think about what a belief on reasonable grounds is, that's something that a reasonable person practicing your job would think. So maybe another youth worker in your shoes who might have the same information to hand. Great, I'll move on to Tina. You're just on mute, Tina.
Of course I am, thank you. In terms of mandatory reporting, there are many different professions on the slide, as you can see, who are mandatory reporters. That includes medical professionals, teachers, etc. You can read those. What is quite many people don't actually realise is that youth workers and social workers, just by the very nature of their jobs, just because of their qualifications, are not actually mandatory reporters. So just a social worker working in whatever field is not a mandatory reporter. They can, of course, report abuse if they suspect it. And youth workers, again, are not mandatory reporters just by the nature of being called a youth worker. You may, however, be a mandatory reporter because of where you work. So, for instance, a social worker who works in a school, a primary or secondary school, would be a mandatory reporter because of the fact that they're working at that school. So because of that, we actually do need to think about a whole lot of different reasons why we may or may not choose to report a sexual or physical abuse in terms of mandatory reporting. So for instance, I'm a social worker who works in a community legal centre. I do not have mandatory reporting obligation. However, I may still choose to report if I believe a young person is at imminent risk of harm due to physical or sexual abuse. That could be something that I could seek consent from the young person. I may find that it's even without consent it might be needed, but in terms of the legal obligation, I'm not a mandatory reporter in this setting. However, if I did work at the local high school, I would definitely be a mandatory reporter there. Hope that makes sense to people, because that's often something that people don't realise about our professions. The reason why we're not a mandatory reporter is because we actually aren't listed under the Act as of a particular date to have actually become mandatory reporters. We're still waiting for that day. That makes sense then? I'm hoping it makes sense to others too.
Yeah, so there's a subset of professions where in the legislation it says on and from the relevant date, this person will be mandated to report, and certain professionals have not yet been mandated to report because they haven't been declared mandatory reporters. That's something that happens by virtue of an order of Parliament, I think, but most importantly, it is recorded in the Government Gazette, so you can look up the record of who's a mandatory reporter, and that's the basis on which we're giving this information.
That doesn't mean, of course, that you don't have an ethical responsibility to report abuse of children. It just means that you get the opportunity to really weigh out what is best in the best interest of that young person. So yeah, I guess why do we have mandatory reporting? It's, you know, we have to think about the rights of the child and Convention on the Rights of the Child, that often children don't report themselves. They're much more likely to speak to an adult, but they won't actually go and contact child protection or police themselves generally. What I can also state is often young people will also rescind that report as well. So they could state that somebody has harmed them and then afterwards say, no, they didn't, because they may be scared of the consequences of reporting that. And yeah, we have concerns about risk of abuse and neglect in our system. So of course, that's one of the reasons for mandatory reporting. Beth, you could probably speak more towards the mandatory reporting of children who experience sexual abuse, I guess. But,
I will, absolutely. I think maybe, Lisa, we might even skip to that slide if that's all right. That's slide 39. Yep, amazing. Thanks so much, Tina. Yeah, so there are two parallel reporting obligations on you as workers in Victoria. One is the mandatory reporting to child protection, which we've just spoken about, and then the second is a duty to report a sexual offence committed against a child under 16 by an adult to the police. It's in a separate piece of legislation and it's a separate obligation. The grounding to this, similar to other kinds of laws, is in recognition that there are high rates of sexual abuse of children and that we need to put an obligation on any adult to report any reasonable belief that a sexual offence against a child is being committed by an adult. So one of the differences between this obligation and mandatory reporting is that any adult has this obligation. So it's not even about certain professionals, it's just anyone in Victoria who's over 18. So that reasonable belief is, again, that if a reasonable person who had your skills and experience would have formed a belief, it doesn't have to require proof or concrete evidence, and it can just be based on things like what a young person tells you, what someone else tells you, or what you observe of a young person's behaviour. And a sexual offence, that definition it's quite broad. So it could be any sexual activity where a younger person can't consent. So we're looking at the age of consent laws there, where obviously under 12s can't consent at all. 12 to 15s need less than a 2-year age gap, and 16 to 17-year-olds need no power imbalance, so no relationship of care or responsibility. So that can apply to these laws. Also, grooming applies, and any attempts. So now we're going to try and apply this information to the case study of Madison. So I'll just pop the case study in the chat, but it's also on page 4 of your whiteboard. So it'd be amazing to see your reflections on there as well. So I will pop that information in there now. And we're just going to go back into our original breakout rooms for this activity, and you're going to have 10 minutes to have a chat. So welcome back, everybody. Thanks so much for bearing with us with the initial tech difficulty with the whiteboard. And I can see now that you've added some really fantastic reflections there to page 4 of the whiteboard, case study of Madison, where we're talking about our reporting obligations in relation to reporting child abuse. I'll just quickly highlight a couple of the suggestions. So we can see here, I would ask Madison if she feels safe to go home next time she comes to the program. We can see noteworthy behaviour change - signs of possibly self-harming, so the long sleeves. This person's saying, in their view, it's not meeting the threshold for a reasonable intervention without further conversation. You can see not reasonable grounds here, the person's saying. So at the moment, they don't feel they've got a belief on reasonable grounds that Madison is at risk. If able to engage the person directly, then chat to Madison with her consent. Otherwise, maybe refer your concerns to the appropriate person in the organisation, such as your manager. And then there's a comment, there's a lot of variables and we need to assess based on a conversation about what she outlines. So a few sticky notes pointing to the value of talking to Madison and attempting a conversation with her about what's happening at home. Someone else is saying the behaviour is noteworthy as it's a big personality shift. Changes could be due to mum's new boyfriend. She could be at risk, but we don't have enough information. Yep. Another person saying, I would talk to Madison and talk to my supervisor about how to approach this. Research further supports for Madison if she needs it. Exploring what is going on with the young person directly. So friendship groups, etc. Change at home, exploring mental health. Document and explore with TL, which is an acronym that you probably are all familiar with, but I'm not quite sure.
Team leader.
Thank you, Tina. Appreciate it. Try to gain more information. Have a private conversation with Madison about your concerns, as right now you don't have enough information. So there's a bit of a theme coming up here.
And it's a very good theme, I've got to say, that added conversation and trying to still assess Madison's needs. Is often assessing needs is a better option than assessing risk, because you are generally assessing the risk as you're assessing what Madison needs, and those conversations are invaluable.
so much, Tina. And I do remember that you commented that it's not unusual that a worker won't have that much information. So this case study is pretty sparse, but that is an unusual circumstance for workers to be faced with.
Yeah, depending on, especially if it's a non-government organisation, they often have the information that is needed for that particular style of work without actually necessarily knowing a huge background of the people that they have there. So yeah, often that information gathering by sharing stories and by speaking to others within your workplace, that such as your supervisor, to really kind of try to nut that out is really important.
Because we are managing our privacy obligations to that young person too by
Absolutely.
not collecting unnecessary information.
Yeah, but yeah, that change in behaviour is generally, I believe every behaviour is communicating something. So it's important to know what that communication is. So yeah, while we may not be reporting immediately, we'd definitely be still keeping an eye out for that young person and having those conversations.
Thanks so much, Tina. So yeah, I think there's some really good perspectives here on the whiteboard, and we would definitely be saying that change in behaviour, it is noteworthy because it is communication, and that there needs to be further conversations with Madison. Tina, is there anything else that you would add?
I'm not sure whether there is anything that I'm missing here. I guess, yeah, again, the idea that we are collecting information that we need. So it's not necessarily appropriate to start asking mum about whether she's at risk, but having a conversation with mum just to see how mum's going as well is a really good way of being able to see how Madison's going, because mum is her protector. So yeah, the idea of just seeing how mum's going, often that can make a huge difference. Just having the conversation without necessarily disclosing anything could be important in that space, providing, of course, that Madison is okay with that too. So we have to assume that somebody has a capacity to understand and speak back and communicate back in whatever way they can. So finding the areas that work best for that young person is really important. So they're finding different ways to make them feel comfortable. That can be sometimes in a car if you do outreach, or, in a playground or in a park or wherever that seems to work at the correct time of day too. So some people are much more comfortable speaking at the end of a session than they are at the start, where all the good stuff really comes out. So kind of leading to that beforehand is a good way of actually learning a little bit more about that. So knowing Madison's really important.
Yeah, that's a really good point too, about also being mindful of Madison's age. So she is in grade 6. So that is part of that constellation of considerations. Yeah. And we are thinking then more actively about parental involvement.
Yeah, very much so. By the age of, by grade 6, they are able to communicate verbally, obviously, but sometimes the behaviour is a higher communication need. So that can also help. So finding ways where she may feel more comfortable speaking with an adult. So that can be while drawing, it can be while on the playground, it could be in the park, it could be a park. If you're at school, obviously that's not a park, but yeah, that's really important.
Great, thanks so much, Tina. And I'm just going to, a good point that was raised between us when you're in your breakout rooms was, the difficulty in distinguishing these two schemes, which both speak about reporting and overlap to a certain degree, but are distinct and are both themselves independent reporting obligations. And one of the things that was pointed to as a distinction is that there are a lot more exceptions to this failure to report law. So that you'll remember that's the one that applies to all adults. Than there are to mandatory reporting laws. And just a few of those exceptions are if the victim is over 16 and they want the information kept confidential, or you're a child yourself when you receive that information. So this is the information about a sexual offence committed against a child by an adult. Or there's counselling privilege applies. So you're a doctor or a counsellor speaking with a young person in confidence. You don't have to share that information, and that's to protect the ability of that young person to seek counsel from their counsellor or their doctor without being afraid that that's going to be reported to the police. The information's already public, or you're a police officer. So there are exceptions to that responsibility on all adults to report sexual offending against a child by an adult. And then there's some reasonable excuses as well. So being fearful for your safety or someone else's safety, but not considering the perpetrator. Reasonably believing that someone else has already reported the offence to police. So that's similar to the sole exception for mandatory reporting, which is thinking that all of the matters that you are concerned about have already been reported to child protection. So we're going to leave this case study here, but really appreciate all of your perspectives. And we're going to move to the last part of our session today, which is to get some further insights and thoughts from you all about what do I do when and what we should do now as youth law in terms of updating this resource. So we were going to do breakout rooms, but we won't do that. We'll just head all of us, if we can, just to the whiteboard together to throw some of our ideas on page 5 to reflect on what we would like to learn. So after our session today, questions that you have, things that you'd like to be highlighted in a new what do I do when? Further reflections now that you've done our training about what could be of assistance to you, or just like any random thoughts or any comments that you think will be helpful to us in the updating of this resource. And I'll, Lisa, I'll get you to just, oh, great, fantastic, thank you. And I should say, don't feel confined by the whiteboard. Feel free to jump into the chat or to unmute yourselves and to say what you'd like included, and Lisa will transcribe it onto the whiteboard as well. Lisa, is that okay? Yeah, amazing.
Just jumping in and checking whether you wanted the recording to keep going.
We might pause the recording now. Thanks so much, Sam, for that suggestion, just so we can all kind of reflect together. I'll just encourage